Welcome to this explainer. Today, we're taking a really close look at the Pakistan Protection Against Harassment at the Workplace Act of 2010, and we're also digging into those absolutely crucial 2022 amendments. We're going to break this whole complex piece of legislation down into a super clear, step-by-step journey, so you know exactly how this law actually plays out in the real world.
Okay, so to really understand our rights and responsibilities here, we've got to go straight to the source. We're looking right at Act 4 of 2010. And listen, we're not just talking about some corporate HR guidelines or a polite company policy here. We are dealing directly with statutory law that legally binds organizations across the entire country. We're going to follow a pretty logical roadmap today. First up, we'll define what harassment actually is under the law, and then see exactly who gets protected. After that, we'll walk through the three main steps of the legal process: the inquiry committee, the competent authority, and the ombudsperson. Finally, we'll wrap up with representation and final appeals.
All right, let's kick things off with Section 1, defining harassment under the law. Because honestly, it's a lot broader than you might think.
Let's bust a really common myth right out of the gate. When we hear harassment, a lot of us instantly think of unwanted sexual conduct or advances, right? But the sheer scope of this legal definition is kind of staggering. The law explicitly states that harassment isn't just about that sexual element. Crucially, it equally covers discrimination based on gender that results in prejudicial behavior. So think about it. If someone is stuck in a hostile work environment or being treated unfairly purely because of their gender, even if there is literally zero sexual element involved, this act absolutely has their back.
Moving on to Section 2. Now that we know what harassment is, who exactly does this law protect?
Thanks to those 2022 amendments I mentioned earlier, the protective umbrella of this legislation expanded massively. The definition of an employee isn't just your standard 9-to-5 permanent staff anymore, no way. It now covers contractual workers, gig workers, freelancers, students, interns, and really surprisingly, even domestic and home-based workers. Basically, whether you're salaried, volunteering, or just working piecemeal, this law was designed to protect you.
And just like the definition of an employee expanded, the legal definition of a workplace goes way, way beyond your traditional office cubicle. Under the law, a workplace is anywhere services are rendered. That means a concert hall is a workplace for a musician. A court is a workplace for a lawyer. It even covers online virtual business environments. Bottom line, if the work happens there, the legal protection applies there.
So this brings us to the really crucial question. If an incident actually occurs, how does this whole legal mechanism spring into action? Let's walk through the exact procedure. And that starts with Step 1, the inquiry committee.
This right here is the starting line for the formal legal process inside any organization. Under Section 3 of the Act, every single organization is legally required to set up a 3-member inquiry committee. And they can't just pick anybody. There's a mandatory composition. You have to have at least one woman on the committee, one representative from senior management, and one senior employee or a rep from the collective bargaining agent. It's built this way on purpose to guarantee a balanced, diverse, and fair initial hearing.
Now, pay really close attention to these numbers because the law operates on some incredibly strict deadlines. We're talking exam-level strict. Once a written complaint comes in, the committee has exactly 3 days to officially communicate the charge to the accused. From there, the accused gets exactly 7 days to submit their written defense. And the whole thing? The committee has a maximum of 30 days from starting the inquiry to submit their complete findings. It's a super swift, tightly regulated timeline, totally designed to stop these cases from just dragging on forever.
Now you might be thinking, what if the accused just completely ignores that 7-day deadline? What if they just ghost the committee and refuse to reply?
Well, the law is completely rigid on this. If there's no response within those 7 days and no reasonable excuse, the committee will proceed ex parte. That's a legal term that basically means they'll just keep going. They'll examine the evidence and make their decision entirely without the accused's input. So, simply ignoring the notice? Yeah, definitely not a valid defense strategy. Once the committee is done, we hit Step 2. The competent authority.
Here's the thing. The inquiry committee doesn't actually hand down the punishment themselves. They just pass their recommendations over to the competent authority, which is usually a group designated by the organization's management. And look at this rapid turnaround. Once they get that recommendation, the competent authority has exactly 1 week, just 7 days, to officially impose a penalty.
And the penalties are no joke, reflecting just how seriously the law takes this. If found guilty, you're looking at either minor or major penalties. Minor penalties might be a formal censure, like a really severe official reprimand, or things like withholding a promotion or docking pay. But the major penalties, they escalate fast. We're talking forced reduction to a lower post, compulsory retirement, massive fines, or total dismissal from service.
And that means you could be permanently fired and blacklisted from returning to that line of work.
So what happens if someone isn't happy with how that turned out? What if the complainant thinks the punishment was a total slap on the wrist, or the accused feels they were totally railroaded by internal management?
That takes us outside the organization to step 3, the ombudsperson. Think of the ombudsperson as your incredibly powerful external appellate forum. Who is this person? The law says they have to be an appointed official who either has been or is formally qualified to be a judge of a high court. That is a massive amount of legal authority. When they're investigating, they literally possess the exact same powers as a civil court. They can summon people, force them to hand over evidence, and cross-examine witnesses under oath. You actually have 2 different paths you can take here. Path 1. If you went through your company's internal process and you hate the result, you have 30 days to formally appeal it to the ombudsperson. But check out Path 2. This is huge. You can actually bypass your company's internal committee completely and take your complaint straight to the ombudsperson from day 1. If you go that direct route, they have 90 days to investigate and resolve it. It's an amazing safety net if you feel like you just can't trust your own HR or management.
And finally, let's talk about representation and final appeals.
Even after a heavy hitter like the ombudsperson makes a ruling, the legal road isn't quite at a dead end. If you're aggrieved by their decision, you've got one final layer of recourse. You have 30 days to make what's called a formal representation, which is basically a final appeal. And this goes straight to the very top, the president of Pakistan for federal organizations or the governor for provincial ones. They then have 90 days to issue an absolute final ruling. Put it all together, and from the day you file that final representation, a definitive conclusion has to be reached within 120 days.
Before we finish up, we really need to highlight Section 11 of the Act. The law is crystal clear here. Making sure all of this happens is the strict responsibility of the employer. Setting up the committee, ensuring a safe environment, the government isn't going to hold your hand and police this day to day. The legal burden and the liability falls 100% squarely on the shoulders of the employer.
Which leaves us with one final, pretty urgent question to think about. Knowing all these incredibly strict deadlines, the severe penalties, and how broadly workplace and employee are defined today, is your workplace actually fully compliant right now? If an incident happened tomorrow morning, does your organization have that mandated 3-member committee ready to spring into action within exactly 3 days? It's a massive question that every single employer and employee needs to be asking themselves today. Thanks for hanging out with me for this explainer. Now take this knowledge and go make sure your workplace is protected.